Welcome to Friday the 22nd of May. I must say, it's a delight to get to Friday this week. It's been another full-on week. I imagine it's the same for a lot of you who are joining us this morning or getting to watch this after the event. So for those who haven't joined us before and don't know what we're doing, my name's Bronwyn Pearson. I'm from Pinnacle People Solutions, and welcome to our daily Facebook Live update. So this is our 10th week of, and thank you for the anniversary shout outs that a number of you have given to us this week for our live stream 10-week anniversary. So we've been, and we will continue to be live at 9:15 every weekday with updates on new information and more detailed information on particular topics that our audience and our clients are telling us that they want to know more about, or indeed where we think, some changes have happened, some things are in the wings. It's really important to get that information out to you. So either way, we're doing this every weekday. Please ask us any questions that you might have as we go along. You can pop those in the chat screen or you can send them via private message. I will do my best to answer them while we're actually doing the live stream. Failing that, I can turn that around at the next live stream and answer those. Otherwise, you can, outside of that, contact myself or my phenomenal team anytime via phone, Facebook, website, email, a whole range of different things. And I'm sure those contact details are going to go up in the chat screen as my lovely team do every live stream. So feel free to contact us in whatever way you need to. There it is. They are fantastic, absolutely. So our company, Pinnacle People Solutions, we specialise in providing the full range of HR advice and support that you might need. And we particularly specialise in supporting regionally based small to medium-sized businesses and not-for-profit organisations. It's an absolute privilege and pleasure to work with our clients. You'll actually get to hear from some of our clients next week. In one of our live streams, we're doing a Q&A with a client of ours, Lysart's Refrigeration and Air Conditioning in Tamworth. We're going to talk to them about their lived experience so far of COVID-19 and the challenges that they've had. So look out for that. That'll be next Wednesday. We've got a whole host of great topics next week to dive into with you. So we'd love to see you. And for you to share that with your friends and colleagues, because the more we get this information out there for business owners and their staff, the better equipped and informed businesses will be. So thank you for helping us with that endeavour. Okay, so breaking news since yesterday. There's one particular piece of information that I think is really important for you to be aware of, and we will put the links up on our Facebook page and our website once we get further information about them. But first of all, the New South Wales government agency iCare, which is the workers' compensation insurance agency and regulator in New South Wales, will today be releasing new guidelines for employers to prepare them for an increase in mental health problems amongst staff. You would have heard from us in our live streams in the last couple of weeks talking about the fact that the National Cabinet and the federal government have introduced a COVID-19 mental health strategy. There is a real concern for the mental health and well-being of employers and their staff during this particular time, and for those in regional locations on the back end of drought and bushfires. It's just, for a lot, it's a bridge way too far. So we're really, really mindful of that. What we know from new research is that a mentally fragile workforce is emerging now from isolation. And that research is showing us that close to a third of workers have experienced severe psychological distress during the COVID lockdown. They're big numbers and big impacts. As you know, every Tuesday we have our consultant psychologist, Jess, giving us some fantastic strategies and tools that we can use as employers and as staff to navigate this really difficult time. She's going to become incredibly important, even more important moving forward than she has been already in terms of those weekly presentations on a Tuesday. So put those in your calendar and tune in for those. Monash University has recently conducted research which has found that social isolation, financial stress, and job insecurity have contributed to 31% of its study respondents experiencing severe psychological distress. The professor leading this study, Professor Alex Coley, who's a psychologist from Monash University School of Public Health, has said that employers now faced a new set of risks to manage as a result of the distress people have experienced in lockdown. And of course, he's highlighted the fact that many people will feel stressed about returning to work because of potential health risks, as well as the insecurity surrounding many people's jobs. His statement, of course, makes a lot of sense. Mental health is going to be a crucial thing for us as employers to identify and manage. So the Monash study focused on more than 1,100 people in a range of industries, either working from home, working less, or who had lost their jobs. And that this is where the figure of 31% were experiencing severe psychological distress, and a high proportion had turned to alcohol to cope. So these are really serious issues that where as employers we need to be really well aware of and have really good support mechanisms in place for our teams. So iCare Chief Executive Officer John Nagel has said that that agency is planning to equip employers with guidance on how to identify mental health risks in the workplace. And obviously safely mobilising a sustainable workforce becomes critical in New South Wales's recovery post-COVID, or any state for that matter. So the employer toolkit, which isn't up on the iCare website yet, I obviously went looking for it this morning, but as soon as we get that link, we will provide it to you in Facebook and on our website, etc. So there will be an iCare employer toolkit available later today, which identifies areas that we as employers can focus on to help our employees feel safe in the work environment. And that will include things like good leadership, communication, and support, some of the things that we've been talking about regularly in the last 10 weeks. The other thing I just want to remind people about, I talked about yesterday morning, and that was following the full federal court determination on Wednesday that as a consequence of a case that was heard there, that casual employees working regular and systematic hours with predictable periods of working time are likely to be considered permanent employees, regardless of whether they've been paid a casual loading. And that's the Workpac versus Rosato judgment. And Workpac has been ordered to pay Mr. Rosato unpaid annual leave, personal leave, compassionate leave, and public holiday payments, which were owing on the basis that he was in fact a permanent employee of Workpac, even though he was engaged as a casual. And there was another Workpac case in 2018, Workpac versus Skeen, which also supported those key principles. And those are that work which is regular, ongoing, and permanent in nature is not genuinely casual, and therefore attracts entitlements such as paid annual leave. Now, I'm not going to go into this in any greater detail right now, because we're actually doing a full expose on this and what does it mean for employers, etc., and for your employment contracts, in particular your casual contracts. We're going to go into that in great detail on Monday's live stream session. So book that into your calendar. Watch this space. We're going to go into that in some detail. In the meantime, Attorney General and Minister for Industrial Relations, Christian Porter, has come out and said that obviously the decision has potentially serious ramifications for a lot of employers and the economy. He hasn't ruled out introducing legislation to deal with this as a consequence, so we'll watch this space. We might know more by Monday as well. In any case, we're going to do a deep dive into the outcome of that decision on Monday, so please put that in your diary and join us then. The other thing I think it's important to note is just some data that's come out as a consequence of a profile on a hospitality worker who lost her job at a popular Hobart hotel, who's filed an unfair dismissal claim. Now, she's alleged that her employment was terminated after she questioned why she was asked to work an extra 15 hours a week in order to receive the federal government's JobKeeper payment. Um, so, um, uh, this particular staff member worked at Customs House for over a year before her employment was terminated. She had been told she would be kept on the books through the JobKeeper scheme. Her employment was terminated after she inquired about having to work up to 25 hours a week cleaning. So she had been working 15 hours a week in very different duties, and she was terminated after she asked about why she was being asked to work 25 hours a week and to clean. The organisation Customs House told staff apparently in late March that it would determine which staff they would keep on, as the coronavirus obviously swept through the hospitality industry, but some staff would be let go because of cash flow issues. At that stage, this staff member was told she would be amongst those who could stay thanks to the JobKeeper program, as long as she spent 20 to 25 hours a week cleaning. And she talked about the fact that she usually only worked 2 or 3 shifts a week, which would be 10 to 15 hours, and that she was a front of house staff member. She asked, together with other staff, whether it was a requirement that she work the additional hours to receive the payment. And interestingly, none of the 5 staff that asked said they wouldn't do it, but all 5 were among staff who received a termination notice 4 days later. So she now has no income. She's not eligible for government assistance. Now Customs House has denied that the sacking of the workers was related to their questioning over the increase to 25 hours a week and the fact that they would be cleaning. It said that employees had been laid off because of coronavirus. There is a conciliation hearing scheduled for next week, so be interested to see what we know more in relationship to that. One of the things, so that's an interesting case. It's not an isolated one, let me be really clear. And we've talked before about the risks to employers of taking certain actions around JobKeeper. You have to be incredibly careful. There is devil in all of the employment law detail, and JobKeeper is not immune in respect of that. So our overwhelming advice in respect of any of those things is get advice before you make any substantive decisions. One thing we've heard from the president of the Fair Work Commission, Ian Ross, is that over the 4-week period to the end of April 2020, the Commission's caseload increased by approximately 40% compared to the same period in 2019. The most significant increases in volume terms has occurred in the unfair dismissal area. So in April 2020, the number of unfair dismissal applications received was 65% higher compared to April 2019. There is a mobilisation of cases that are coming and are increasingly being lodged in respect of employer decisions during COVID-19. I can't emphasise enough how careful you need to be as an employer to make sure that whatever decisions you're making are lawful. So please get in touch with us for advice. So today's topic is leave during COVID-19, and particularly managing paid and unpaid leave. So what I wanted to do this morning was give a recap on the main forms of paid and unpaid leave and how they've been varied for the period of COVID, what your obligations are as employers for those who are listening, and employees to know what your entitlements are. Get in touch with us, of course, anytime, by all those various means that you have to contact us. So yeah, please do that, because you could find yourself in real hot water during this period of time by not knowing what you don't know. So please get in touch. So the first thing I would say is that obviously back on the 9th of April, we goodness me, it must be Friday. We saw The government introduce unpaid pandemic leave and annual leave changes to modern awards. So first, in terms of unpaid pandemic leave, on the 9th of April, modern awards were updated to provide up to 2 weeks unpaid leave for an employee required to self-isolate or who is otherwise prevented from working because of measures taken by the government or medical authorities in response to the COVID-19 pandemic. It also allows an employer and an employee to agree to take double annual leave on half pay. Some of the important things to note about unpaid pandemic leave is the granting of leave is up to 2 weeks and so is therefore as such could be shorter than that period. The leave must commence before the 30th of June, but it can continue past the 30th of June, but it has to have commenced by then. You can, as an employer, request evidence that the leave is being taken in response to government measures or due to the impact of COVID-19. All of these, of course, presume that you have a really good, robust leave policy in place. So if you don't have that, get in touch with us. We can help you make sure that that's in place. Also, as employers, you may agree to give a staff more unpaid pandemic leave than the entitlement of 2 weeks, but you're not required to. Obviously, also back on the 9th of April, the Fair Work Act was amended to support the implementation and operation of the JobKeeper scheme. There was on the 9th of April, as I said, the Fair Work Commission made the determinations varying 99 of the 120 odd modern awards to provide 2 weeks of unpaid pandemic leave and the ability to take twice as much annual leave at half the normal rate of pay. This is on the part of staff if their employer agrees. So the schedule in each award applies from the first full pay period on or after the 8th of April until the 30th of June. Now that end date can be extended by application to the Commission. We haven't heard anything about that yet. We're only at the 22nd of March, but if we're going to hear anything, it'll be coming into May, well, coming into June. So we'll keep you informed about that. I've mentioned about unpaid pandemic leave. If you're an employee and you need to take unpaid pandemic leave and you've got an entitlement to that under one of the 99 modern awards, then you need to let your employer know that you're going to take unpaid pandemic leave and the reason for it. You need to do that as soon as possible. It can be after leave started, but you need to do it as soon as possible. And you should also say how long you'd expect to be off work, and your employer can ask you to give evidence that shows why you needed to take the leave, as I mentioned before. It's incredibly important as employers that we remind ourselves that we cannot dismiss the employee or take any other adverse action against them because they're entitled to unpaid pandemic leave or indeed any other form of leave. So that's one of the big issues around protections at work. So, and the case I just talked to you about of this person that who was employed by Customs House in Hobart is taking an adverse action and an unfair dismissal claim. So the other thing I would say about unpaid pandemic leave is that if as an employer you are entitled to the JobKeeper wage subsidy and your particular staff member who may need to take unpaid pandemic leave is also eligible to be paid the JobKeeper wage subsidy, then anybody who is therefore entitled and receiving JobKeeper payments from their employer can still take unpaid pandemic leave at the same time as receiving the JobKeeper payment. In fact, for most forms of unpaid leave during the COVID-19 pandemic, if you as the employer are eligible for JobKeeper and your staff member is eligible to receive the JobKeeper payment, they will get paid JobKeeper during a period of unpaid leave. So if you've got any questions about that, please get in touch with us. There are a couple of exceptions to that, and I'm going to talk about that in terms of unpaid parental leave, and I'll get to that in a moment. But if you've got any questions, which you may well do, get in touch with us and ask, because we're very happy to answer any and all of those. So the other JobKeeper changes that were made to the Fair Work were around annual leave. And those are, if you are a qualifying employee under JobKeeper, if you're not, this doesn't apply. So for those who are eligible under JobKeeper, you can request an eligible employee, so only one of your staff who's eligible for JobKeeper, to take paid annual leave as long as the employee keeps a balance of at least 2 weeks paid annual leave in the kitty. You need to get an agreement in writing with that employee for them to, or you can agree in writing with that employee for them to take annual leave at half their usual pay, including annual leave loading if that applies, if they're under a modern award where that applies, for twice the length of time. The employee has to consider the employer's request to take annual leave and can't unreasonably refuse it, remembering this is under JobKeeper. If an agreement is made under the JobKeeper provisions, then it applies instead of the employee's usual terms and conditions about taking leave, so annual leave. So there is this particular provision for JobKeeper eligible employers and their employees. So essentially, under that new schedule, employees can take their annual leave at half pay and double their time off work if their employer agrees. This means that they would get 1 week's annual leave payment for every 2 weeks of annual leave that they take. The agreement would need to be in writing, and the employer needs to keep that written agreement as a record. All of the things that you would need, that you might be looking to do under JobKeeper, ordinarily we'd be advising you to keep everything in writing, of course, as a matter of default. But it's even particularly more so and required by legislation that you keep these things in writing. The leave needs to start before the 30th of June, but it can finish after that date. Now, an incredibly important thing to remember about this new provision in terms of annual leave at half pay is that an employee on leave at half pay will nonetheless continue to accumulate annual and sick and carers leave as if they were on leave at full pay. So any period that they're taking of half pay, if you agree or you ask them and it's agreed that they're going to take the annual leave, leaving 2 weeks in the kitty, and they're going to take it at half pay, they nonetheless still accrue their leave entitlements to annual and personal carers leave at the full rate of pay. If you've got any questions about that, talk to us. Okay, so let's have a quick look then at personal carers leave. And again, I'm watching this chat box carefully to see if you've got any questions that are coming up as we do this. So in terms of personal carers leave, and we had a lot of questions about that, less so now because schools, public schools in particular, are going back full time from next Monday. But we've had a lot of inquiries over this period of time about the use of personal carers leave for employees that need to look after their children due to school closures. If you've got any questions about that in retrospect, maybe you haven't worked out what to do with that yet, get in touch with us. An employee can take carers leave to provide care or support to an immediate family or household member where the care and support is required because of an unexpected emergency. And at the time that schools were closed partially or fully, during the COVID climate, that would certainly have amounted to an unexpected emergency. That is a question that we've had a number of times. We've also had the question, and this will continue to be an issue beyond COVID, but what if an employee needs to look after someone that is ill, including a child or a family member who's ill or who requires support due to coronavirus? And obviously, in terms of their entitlement, any staff that you have that are entitled to personal carers leave may take that leave to provide care and support to an immediate family member or household member where the care or support is required because of personal illness or personal injury. And provided that person in the household is suffering from an illness and needs you to look after them, the employee would be entitled to access their accrued personal carers leave. There are rules around who qualifies as a family or household member, as there are rules for payment and evidence. Those rules would ideally be in a very good and robust leave policy that you as the employer would have. If you don't have one, get in touch with us and we can help you with that. It's incredibly important that you do. This isn't the only policy framework that you should have in place, but for the purposes of today, incredibly important. What if an employee needs to look after their children due to school closures but has no personal leave left? You have a few options in that respect. You may decide to pay the employee as an exercise of discretion. Again, that would be entirely discretionary. You're under no obligation to do that. In replacement for this, the employee could take leave without pay, subject to any leave without pay policy that you may have. So talk to us if you don't have a leave without pay policy and you're thinking about whether you should have one. Get in touch with us about that. Or they could access another form of paid leave, such as annual leave or accrued long service leave, if they have those balances and entitlements. All right, so let's talk for a moment about long service leave, because on the 27th of March this year, there were amendments that were made to the New South Wales Long Service Leave Act to allow employees to take leave, and long service leave that is, in shorter blocks, for example, 1 day a week. It also removes the traditional 1 month notice period with agreement from the employer. So those legislative changes were aimed at giving businesses additional options to draw down on their existing leave options and maintain cash flow. The increased flexibility has been and continues to be incredibly important during a time when business owners are doing everything they can to keep staff on their books. The legislation will be in effect for 6 months from the 24th of March, with the possible extension for up to 1 year. So you've got 6 months from March with those temporary changes to the Long Service Leave Act, which means staff can take leave in shorter blocks, for example, a day a week, and also removes the traditional need for 1 month's notice. Okay, where are we? So the other form of leave that I think it's important for people to be aware of in general, but also over this period of time, is family and domestic violence leave. Now, that was introduced earlier into all of the modern awards, and it is 5 days of unpaid leave. There is particular concern around family and domestic violence and working from home during coronavirus. And we've actually provided this advice and support to a number of employers during coronavirus, because for some employees, obviously working from home may not always be a safe option. And so we've got access to guidance and advice that we can share with you regarding alternate work arrangements during coronavirus for those experiencing family and domestic violence. All employees, including part-time and casual employees, so this is irrespective of the nature of their employment, are entitled to 5 days unpaid family and domestic violence leave each year. It resets each year, it doesn't accumulate. And the entitlement to unpaid family and domestic violence leave comes actually from the National Employment Standards. So they're the minimum terms and conditions of employment that apply. That has been introduced to those. So it will apply regardless of whether you're covered by a modern award. We can give you access to definitions about what domestic and family violence is. The all industry and occupation awards include unpaid domestic family and violence, unpaid family and domestic violence leave, including obviously in the national, those in the National Employment Standards, and the award entitlement is for the same amount of leave, so 5 days unpaid. It is really important that you make sure that you have a policy around this particular leave, and make sure that your staff are aware that they have that entitlement. That's incredibly important. So talk to us if you need some support with making sure that those that staff are aware of those entitlements, and that you have an appropriate policy that covers how and when and why and those sorts of things. I mentioned before that we would also talk today about parental leave. So particularly as it applies to COVID. So in most cases, parental leave from an employer is unpaid. Some employers have a paid parental leave scheme. and there is slightly different expectations in respect of that, but most small to medium-sized employers will be required to provide unpaid parental leave to their staff members that qualify to take that. It is one of the forms of leave under the National Employment Standards, so it applies to anybody employed under the federal employment law system, irrespective of whether they're covered by a modern award. In respect of the period of COVID and all of the weird and wonderful changes and additional regulations and things that have come in for this period of time, if your staff member is on or going on unpaid parental leave and they're eligible to receive and are receiving the government's paid parental leave scheme, then for that period of time that they're getting the government's paid parental leave scheme, they're not eligible for JobKeeper. If they're receiving paid parental leave from you as the employer, if you have a paid parental leave scheme and they're receiving that from you, and they're not receiving the government's paid parental leave scheme, let's say they were for a period of time and for the remainder of their unpaid leave from you, they're not getting it, or they're not eligible for it, so they're not getting it at all, then they are eligible for JobKeeper if the employee and the employer are otherwise eligible for JobKeeper. So really important to know that. We've had lots of questions around this. So if you're providing a paid parental leave scheme to somebody in your employment and your company is eligible for JobKeeper and they are eligible for JobKeeper, then they will get JobKeeper during that period. If they are on unpaid parental leave from you and not receiving the government's paid parental leave scheme and you are a JobKeeper eligible employee and they are, then they would also get paid parental JobKeeper. If they're getting the government's paid parental leave scheme and for the duration of the 18 weeks that they may be eligible to get that, they would not be eligible for JobKeeper. A lot of information to take in this morning, I realise, over so many different types of paid and unpaid leave. I realise it can be incredibly confusing, making sure your payroll system is calculating leave entitlements at the correct rates over this period of time, given the accrual rate sort of implications for half pay and those sorts of things during JobKeeper. Get in touch with us. If you've got any questions whatsoever, please get in touch. We can help. Okay, so the practical realities coming out of today's live stream are: make sure you understand your obligations as an employer around paid and unpaid leave, and that you completely understand your staff entitlements to paid and unpaid leave and how that needs to be done, what records you need to keep, what accrual rates you need to ensure. Any questions whatsoever, give us a call. Make sure you have a robust leave policy and potentially also an unpaid leave policy. Talk to us about that. It's incredibly important that you have good, robust guidelines in place during, well, always, normally, but particularly for during this period of time where there's so many things that have changed. If you're unsure about anything at all, get in touch. Very happy to give you specific advice for your business. So look, thank you so much again for joining us today and for joining us this week, our 10th week of doing daily live streams on information and topics of particular significance for our business owners out there in our regional and rural communities and their staff. If you have any specific questions whatsoever about your business or you want us to help you out, contact us, of course, anytime via the contact information that we put up there in the chat screen for today's live stream. Please join us again on Monday. On Monday, I'll actually be doing a deep dive through the very serious implications of this week's federal court decision on the Workpac Casuals case and those implications for businesses. So please join me on Monday. This is a very serious, this has very serious implications for any businesses that employ casuals. So please invite your colleagues and your friends to join us on Monday for that deep dive. We've got a fantastic week of topics coming up next week, including on Tuesday, Jessica is going to be talking about the psychology and strategies, etc., for relocating. That's for both employers and employees. On Wednesday, we're going to be talking to Joe and Stephen Lysart from Lysart's Refrigeration and Air Conditioning about their experiences during COVID. And on Thursday and Friday, I can't immediately remember what our topics are, but they're equally compelling and interesting. So mark us in your calendars for 9:15 each morning next week, or feel free to come up onto Facebook, YouTube, our website, LinkedIn, and you can always see the live streams after the event. They're recorded and archived. We're also producing fact sheets related to each of them. They'll be going up on our website progressively, so you can get access to those as well. Of course, you can contact us anytime. We'd be delighted to answer any questions that you have and talk with you about what is relevant for your business. In the meantime, before I see you again on Monday, please hug the people that you can. Wave cheerily to those that you're not yet allowed to. Have a fantastic weekend. We're getting some of the beautiful wet stuff here in Armidale in the last 24 hours. I do believe it's been more widespread over the region, which is we desperately need. People forget in the midst of COVID, well, not a lot of people forget who live in regional and rural communities, but the wider public tends to forget that we are still drought and bushfire consequence affected in a lot of rural and regional communities. Water supplies are still at critical levels. And so there's a lot of challenges facing regionally based business and their staff at this time, and we're acutely aware of that and want to be able to support you in any way. So have a fantastic weekend. Stay rugged up if you're up this part of the high country, because it'll be lucky to be seeing to be double digits this weekend. In the meantime, stay safe. Stay home unless you absolutely need to be out and about. Wash your hands, great hygiene, and we'll really look forward to seeing you on Monday. Thanks so much again for joining us.